Megan.
Good morning, how are you? Let's see.
Stay here last night?
No, I actually came in this morning. How about you?
Same.
Yeah.
Just resting real quick.
the appellant?
I have no idea. I assumed this side, I'm the appellant, so I assumed this side, but I don't know that.
Sometimes it says on it.
Yeah, I haven't seen anyone in here to ask either, so.
Yeah. Well, I'm not the first case, so I'll let you guys figure it out.
Very good.
because of the electrical outlet. How's it look now?
A little more,
A little more?
a little more. A little more.
Huh?
I think that's good. That had a pass.
Good now, just square? No, Judge Orfinger's not here, but you, oh, no, it's way out of whack.
We're live.
Judge Orfinger would notice it, even though,
Yeah. You might have overcompensated.
Of course you did.
you ever tried moving this thing?
I know. It
It's
looks
like
heavy.
500 pounds.
Yeah, it looks heavy.
What's real fun is when we have induction ceremonies and we move it over there.
Oh my gosh.
Oh,
Get some wheels on that.
that's definitely a Wheaties morning.
Absolutely.
There we go. Thanks, man, for letting me know. Forgot I moved that. I guess it's something we're doing a Zoom and we're doing kind of like we did a couple weeks
I'm
ago.
like, what if you're short? That thing's so tall.
I need like a phone book just to have
I know. I mean, I'm like, I'm not that tall, but that thing's pretty imposing.
the whole situation is imposing.
Yes, you nailed it. You nailed it. Nothing about this is,
No, it's not made to put you at ease.
no, for sure.
You know, I had an oral argument last month at the first district, but they took the show on the road to like,
Lake City.
right,
I'm from Lake City.
oh, are you?
And I wanted to get over here and something popped up that day and I didn't make it.
And it was funny because, you know, the courthouse is really designed for an argument.
Sure.
So they had it in a courtroom, but this little table set up with the three judges like
At this
shoulder to shoulder, stuffed in this little table. And I was standing up like 10 feet in front of them, higher than they were.
Wow.
The whole thing was
really odd.
yeah, it was
I had one at University of Florida one time, and it was a lecture hall, so it was better, but still not obviously the ideal setup. So
Well, sometimes the law schools have like, you know, appellate courtrooms,
Sure,
like,
sure.
like the second DCA. I think they, you know, for years they did the oral argument at, I think it was Stetson.
okay, that makes
Yeah.
sense.
Yeah, and enough seats for every student in the school to come.
Yeah.
But yeah, the circuit courts, you know, Lake City I was the only case there that morning.
Were you really?
Yeah, well, I think there were originally three, two of them settled.
Okay.
So it seemed, you know, I guess for PR reasons, they got to take the kid in the court around.
Yeah. I mean, it's nice to see them, and that's it. Get them out of their home territory. So yeah.
Yeah. Sometimes when I've been in that situation, they'll like bus students in
Yep.
and they'll watch the oral arguments. And, you know, I wonder, do they have any concept of what's going on? It's not like what you see on TV.
Absolutely not even close.
Right, there's three, you know, there's no one's testifying,
Right.
there's no verdict announced at the end.
Absolutely.
So it's,
And it's hard to kind of jump in on a case that you're just talking about specific issues versus,
and what do you explain to them? Now, this is a case that's already over.
and that's it. Sort of, yeah. No, you're exactly right.
Maybe it's over, maybe it's not.
That's right.
So yes, it is a, it's a problem.
It is.
just for dramatic effect.
The Court of Appeal in the 4th, 5th District of the State of Florida is now in session. The Honorable James T. Edwards, Judge presiding. All persons having business before this court draw near, give attention, you will be heard. May God save the United States of America, the State of Florida, and this Honorable Court.
Good morning, everybody. I've been introduced. I'm Jim Edwards. To my right is Judge Scott Makar, a relatively new member to this court, but a veteran of the Courts of Appeal. And to my left is Judge John Harris. We have 3 civil cases this morning. Everybody gets 20 minutes per side. We typically reserve 5 minutes for the appellant for rebuttal. If you want anything different, just let us know. I'd be happy to give you whatever time you want. If you have any noisemakers, which everybody does, please turn them to silent or turn them off so that you don't interrupt your colleagues, or worse yet, interrupt one of us judges while we're asking you a really deep probing question. The setup here with the clock is fairly simple. When you have the green light, you have all your time available. When you hit the yellow light, you are into your rebuttal time. Red light, it's time to sit down, unless we say otherwise. So with that, we'll start off with Starbucks versus Gold, and that's case 23-157.
May it please the court. Megan Logan on behalf of appellant Starbucks. As I got into my car this morning to arrive at the courthouse, I was greeted by a disclaimer on the console of my car. And that disclaimer said, "The driver is responsible for safe operation of this vehicle." The driver is responsible for the safe operation of this vehicle. A concept so simple, even a car recognizes it. Yet it was overlooked repeatedly in this trial. It was overlooked first by the trial court at the directed verdict stage, then by the jury, and ultimately by the trial court again in a motion for new trial. And that's where I'd like to begin, with the denial of Starbucks' motion for new trial. The motion for new trial was based on the premise that the jury's verdict finding no negligence on the part of defendant Ward was against the manifest weight of the evidence. The evidence supported negligence as to defendant Ward overwhelmingly. And when I say that, the evidence supported all 4 elements of negligence. It was undisputed that there was a duty on behalf of defendant Ward to use reasonable care in the operation of her vehicle. That was echoed by Dr. Bushagi in his testimony, and actually even began before that, and obviously recognizing there's a difference between argument and evidence. It was acknowledged in the opening statement of defense counsel for Ward.
Counsel, what warning signs were there to let the driver know that this was a pedestrian area?
There were no specific warning signs, Your Honor, but one of the arguments made in this case is, what good would a warning sign have done for someone that wasn't looking? Ward's testimony was that she never saw a pedestrian in this area in the over 300 times.
I mean, if there was a sign there, it's very probable she would have seen it at some point. I think the testimony was she just looked down momentarily, and that's all it took. And that's typically all it takes in every accident, right?
That is, Judge. And again, though, I think the suggestion that a warning sign would have prevented this accident is a little bit of a misnomer. And when I say that, Ms. Ward had been through this drive-through over 300 times without incident. And so it was this one occasion, the perfect storm, where she looked down, looked away, negligence, a breach of the duty.
That seems to suggest that this was a one-off. She'd been through it 300 times before.
I think it was a one-off, but I think it was a one-off of the perfect storm of conditions that couldn't be created, essentially if you tried. And I think the suggestion that all these warning signs, crosswalks, pedestrian crossings, all of that would have prevented this. I think, again, she and others clearly went through this drive-through on numerous occasions without any incidents, without any interactions, as evidenced by the lack of prior accidents.
What percentage of fault are you arguing that is attributable to her?
You know, I think that could range, but I think the reality is, in closing argument, counsel for Ms. Gold suggested that if you're inclined to award Miss Ward some fault or assign her some fault, it could be anywhere between 0 and 1%, and the jury went with 0. I think that's the problem, in essence. I think even 1% would have showed that the jury accounted for the evidence, which was overwhelmingly that Ward bears some responsibility for this accident. So again, I think it ranges, but I think the reality is even 1% would have acknowledged that, and I wouldn't be here making this argument, but the 0 suggests that the jury's verdict was absolutely against the manifest weight of the evidence and should have been
If
remedied.
we agree with you, it'd be a new trial on liability only, correct?
I think so, unfortunately. I think, you know, as with anything, I think we're talking about liability, and I think we're talking about what percentage would be awarded to Ward. You know, I know there has been, you know, suggestion, even as to the other argument, that, you know, Fabre cases are applicable, and I think, again, that's not a given, but the Bada case that we cite did the same thing and awarded a new trial as to liability only. So moving back to the denial of the motion for new trial, the evidence absolutely supports all 4 elements of negligence. It supports that there was a duty and that duty was breached. And when I say that, the argument or the testimony of Dr. Bushagi was that Miss Ward, as any driver, had a responsibility to look where she was going. When she didn't do that, there was abundant testimony regarding causation, and that Gold's injuries were caused by the crash itself. And that was found in the testimony of Dr. Bushagi, Dr. Lichtblau, and even Dr. Hastings, who opined that her injuries were the result of impact between a Jeep Grand Cherokee and Miss Gold.
Excuse me, I should know this, and I apologize for asking.
Sure.
How fast was the vehicle going at the time of impact?
There's an estimate about 3 to 4 miles per hour, Your Honor.
So basically idling.
Correct.
Okay.
And so
Did Ms. Gold come out right in front? I saw there was 2 videos in the record. Did she come out right in front of where the car stops at the window, or did she come out at a different location?
yeah, there's actually no video, Judge. There's some photographs that show the car.
Oh, there was a video just of a drive-through. It wasn't of her
Correct.
getting hurt. It was just, it graphically showed you, including the one where you had to wait in line, I guess in line with the very compelling closing argument of how thirsty and hungry you get waiting in that long line. But
Absolutely. And you're referencing the videos taken by Dr. Bushagi as part of his expert testimony. But the testimony in the case was that Miss Gold, in essence, had come out of the door and around the patio, and it was as she came around the patio that she encountered the Jeep Grand Cherokee that was pulling out of the drive-thru. The only evidence that Miss Ward was not at fault was the conclusory testimony of Dr. Bushagi that her actions were reasonable, that these were the actions of a reasonable person. I would submit that that flies in the face of everything we know about driver responsibility, and or even the suggestion that she looked away for a moment and that was somehow reasonable. That's the stuff that punitive damages are made of. I mean, courts every day find people responsible for punitives for looking away, for texting and driving, for looking at their phone. And all of a sudden, based on a conclusory opinion of a paid expert, it is now a reasonable action to stop in the drive-thru and look down while your vehicle
I'm
is
not
rolling.
sure I've ever seen a case where just looking away for a moment ends up being an intentional act justifying punitive damages. I'm not sure what you're talking about.
I don't think it's an intentional act, Judge. I think the suggestion or the analogy was that, again, it's not reasonable to look down while driving, which is absolutely what she was doing. She was not stopped. Her foot was not on the brake. She was in movement. She was driving. And I think the suggestion that that's reasonable, again, is a conclusory opinion that fit the circumstances of plaintiff's case, but it shouldn't.
it certainly fits, though, in the expert's opinion that it's foreseeable and that Starbucks should have guarded against it. Correct? I mean, you agree with that.
I don't agree with that. And I think part of that is, one, how do you ever guard against drivers in your drive-through rolling? I don't know that you do. I don't know that you
But
can.
there's not a duty to make it foolproof or absolutely safe, but to take some steps to reduce the risk. I think that's what the expert was talking about, wasn't he?
Yes, but again, I think, how does one do that? And I think the idea being, would a sign have kept her foot on the brake? Would a sign saying, don't look at your coffee, pay attention to the road? I don't think any of those things.
People run stop signs all the time, but if you don't have a
Absolutely.
stop sign there, oops. I mean, so here you are, and you have people, as the one video shows, waiting in line. It's not like you whip up there unless you just have the luck of the day. You're usually in line waiting, so if there are signs or warning signs, it might, not necessarily, it might plant that in your mind, and that would be a reasonable thing for a business owner to do. I mean, that's the crux of their case, wasn't it?
Yes, it's certainly not unreasonable to do. But again, the idea being, from our perspective, when you talk about foreseeability, this had never happened before in 4 years. This had never happened before with over 140,000 cars through that drive-through in the year that this accident occurred. And so when you talk about foreseeability, what is that based on? I mean, the fact that, like you said, it could potentially happen because it's not foolproof, and that therein lies the problem. And so when you talk about foreseeability, as Dr. Bushagi did, and the fact that, you know, it was Miss Ward's actions were reasonable in rolling through the drive-through and in looking away to secure her coffee, I think that's a conclusory opinion not based on any facts or inferences in the record. And the Federated case, one of the cases we cite in support of our claim that the trial court erred in granting the fourth motion in limine, says that where a conclusion or opinion of an expert witness based on facts or inferences not supported by the evidence that in such case that opinion has no evidentiary value.
I thought there was, I'm sorry for interrupting, but I thought there was some evidence that basically said that in the design of this, there were recommendations made about having certain safety features put in, and those weren't adopted.
There were various revisions and layouts of this, some of which had them, some of which did not. And again, that segues into my empty chair defense, but those were all the decision of the landlord owner, not Starbucks. And so certainly Starbucks had oversight, had the ability to request or, again, review those, but the various revisions were the work of the landlord, and hence ties into our empty chair defense in this case. So again, the same arguments made in support of the argument for denial of the motion for new trial are equally applicable to the motion for directed verdict that was made both as at the close of plaintiff's case and at the close of all the evidence as towards negligence, and we think that should have been granted as well. I'd like to touch on the duty allegedly owed by Starbucks, and in turn how that flows into the empty chair defense. In this appeal, Starbucks is asking this court for a determination that under the facts of this case, it, as a tenant of a multi-tenant commercial building, owes no duty to invitees where the duty is expressly reserved to the landlord. And in the briefings, you've seen arguments that that standard is simply not applicable. It's only applicable in cases involving criminal attacks by a third party. I would suggest that's not the case. I think both the Diaz case and the Martinez-Mare case support the fact that they can be used in other cases aside from criminal assaults by third parties. The Davis case is silent as to the exact facts of that case, but there's no suggestion that it was a criminal assailant. I also think that when you look at the reasoning or the rationale behind the application of such a standard to criminal assailants, it's much more like the facts of this case than it is to the static conditions that existed in either the Levy case or the Burton cases that are cited within the briefs. You know, first of all, you talk about a criminal act of a third party, and the court's rationale in applying that standard seems to be, again, that there was no foreseeability, that there was no warning that could be given by the tenant that would have prevented such a situation. And I think here there's a similar concept in that it was a third party, Ward, that caused the accident. And again, what warning could Starbucks have given? Obviously, a warning to look for pedestrians, look for traffic, but again, no guarantee that any warning would have prevented this accident.
But isn't Starbucks a little different here than, say, a shoe store in a mall or something? Starbucks had the right basically to override any of the plans that the landlord came up with, didn't it?
It did have that right, but again, I mean, I think it's important to look at this in context, which is, you know, the services and the professionals that Starbucks utilizes and has on the project. And so when Starbucks opens a location in various jurisdictions, it does so relying on the landlord, on local building officials, on all of the people involved to ensure that it meets code, to ensure that it's, you know, that all of the safety standards and the best design possible is adopted. Starbucks looks at those plans, again, mostly from a, you know, kind of PR or utility standpoint for their operations. I mean, how many cars can you stack in a drive-through safely? You know, how many customers can you serve? Those type of things. But they are not boots on the ground, hired, you know, architects, surveyors, engineers, all those things to ensure that it's the best design or even, you know, an alternative design.
What if there's a car backing out of a parking space in the parking area and backs over a customer walking through? Is there a duty on Starbucks there, or is it duty on the owner of the parking lot, the third party, or how does that play out?
Yeah, I think assuming it's a common area, as this was defined under the lease, the landlord takes responsibility for that. And
So I was hoping to hear more about the landlord not, you know, being part of the verdict, but.
sure, and I'm happy to address that. I see that I'm into my rebuttal time, or I can address it on rebuttal.
That's fine.
Okay.
It's your time.
Thank you.
Good morning, Your Honors. May it please the Court. I'm Curry Pagic, and I represent Sherry Gold, the appellee here, and the plaintiff below. Starbucks Corporation received a fair trial, and it's not entitled to a do-over on liability. The trial court did not abuse its discretion in any of the issues in this case, not even close. So let me address first what the defendants, Starbucks appellants, addressed in their argument to begin with, the negligence award. They have waived any appeal on that issue. They did not make a motion for a directed verdict on the issue. They waived it. 1.480A is a rule we all share. It's a rule that protects us all. It's the law in the state of Florida. Number two, they did not file a post-trial motion to set aside the verdict on the issue of negligence. 1.480B. They've waived the issue, and that's the issue they started out with here today. Even if it had not been waived, the overwhelming evidence that Starbucks negligence caused this incident. Starbucks had control from day one. They had the right to control the setup of this entire property, and they exercised that right. From up on high of Mount Seattle, they directed exactly what happened in Nassau County. Not only did they design it, they designed out the safety. There is not one iota of safety in this design. They designed it in. They took away the stop bars that were in the original design, Starbucks' original design. They took away the stop bar for the exiting drive-through traffic. Number two, they took away the sidewalk, which was there for safety for people just like Miss Gold. Could have been a 6-year-old, could have been a 72-year-old person like Miss Gold, could have been a mom with baby carriage that got ran over.
Counsel, I'm sorry to interrupt, but I mean, let's accept that there was negligence by Starbucks. But
Yes,
but that doesn't get us a resolution of the issues on appeal, correct?
Yes, sir, you're correct. The issue's on appeal. Then I will jump to those. Yes, sir, Your Honor. First, they talk about the fourth motion in limine and the issue of the duty of care to customers. Clearly, that is an issue of law for the court. The court determines the issue of duty, Not only did they not appeal, did they not move for summary judgment on that, they never moved for a directed verdict on the issue of duty. They have never filed a post-trial motion on the issue of duty.
Let's focus again on how is it okay for Ms. Ward to not look where she's going while her vehicle is moving forward. I mean, she was going slowly, but if you ask Ms. Gold, it hurt and caused her damages to the tune of like $8 million, right? So whatever she did factually caused the injuries to Ms. Gold. And how is it that a jury can find she was not at fault 1% or 0.5% or something? I mean, I think in the grand scheme of things, since it would be a trial, new trial on liability only, I don't think it's going to change the price of a Starbucks cup of coffee, but how can a jury come back with the evidence presented and not find her at least some percent at fault?
The question is, was this a zone of risk created by Starbucks? Was it reasonably foreseeable that this would happen? As the court talked...
No, that's not the question. My question is, how can a jury not find her driving forward with her foot off the brake, not looking where she's going, some percent at fault?
Well, there's two issues. First, this is a question of fact for the jury. The evidence was overwhelming that this is something that is reasonably foreseeable to occur. Number one, was it negligent? Number two, did it cause the injuries? Did it cause the injuries? The jury could say, A, either one, she was not negligent, or B, the cause, the proximate legal cause of this incident was Starbucks creating the trap. That both of these...
I'm sorry, I think, at least I'm hearing Judge Edwards wants you to address the 0% assignment of fault.
If I could refer to the case of Valenti versus, excuse my pronunciation, Sareva. It's 292 Southern 3rd 50. So it's the second DCA 2020. In that case, a motorist changed lanes into a motorcyclist.
And the motorist said he looked carefully before he moved. The jury could believe him or not. I'm familiar with that case.
Yes, sir.
We don't have that here. We have Ms. Ward was not looking where she was going with her foot off the brake, even though she's going 3 or 4 miles an hour. I mean, it's not horribly reckless like, as I'm sure you saw some folks on I-95 and I-4, it's not that situation. I mean, nobody's claiming Ms. Ward is a terrible person, but that case is not our case, is it?
Respectfully, Your Honor, this was a blind corner created by Starbucks. She came around a blind corner created by Starbucks. There was a sidewalk there for the pedestrian to step on to look to see if the exiting from, this happened in the drive-through lane, which was under the exclusive control of Starbucks. There had been a sidewalk. Starbucks at the last minute wanted more space on their patio.
I get that. Trust me, I understand that. I saw the evidence on the other Starbucks.
Yes, sir.
I find it hard to believe that the Starbucks here basically agreed with jettisoning most of the safety things other than the little black rail there. But again, somebody heading towards a blind corner who's been through there hundreds of times or at least 100 times, how is that okay? I mean, it's not like a light blinded her at the last second or something like that. I mean, she wasn't looking where she was going and she hit your client.
It's the jury's job to make that determination, Your Honor. It's a question of fact.
There was no question of fact, but that she was not looking where she was going, right? I mean, it's undisputed. Undisputed, she didn't have her foot on the brake, so it was undisputed. She was moving forward and simply not looking where she was going. It's undisputed that cause in fact was she hit Ms. Gold, right?
Yes, sir.
Okay, so again, how can that not be some percentage negligent?
That's the jury's job to determine who caused this approximately.
And if the jury gets it wrong because it's against the manifest weight of the evidence, it's the judge's job to order a new trial on liability, if that's the situation, correct?
That is the court's decision. Did the trial court abuse its broad discretion?
Well, let me follow up on this question. I thought I understood your theory to be on the 0%, which is that the jury could go back and deliberate and say, gosh, it really looks to us like this wouldn't have happened if Starbucks had done their job and had adequate warnings and so on and so forth. So we're not going to necessarily excuse what the ward did, but we understand in the context of comparative negligence, we think it's 100% on Starbucks in this instance.
Yes, sir.
And I think, I'm not making your argument for you, I think that's,
Yes, sir.
I think that in that your argument, then your briefs are.
It is. The jury decided that this is 100% the fault of Starbucks, not the driver, because this is something that Starbucks should have foreseen and
I'm sorry to
prevented.
interrupt again, because I know we have limited time.
Yes, sir, Your Honor.
But
Thank you.
do you have a case out there, is there a case somewhere in Florida, maybe elsewhere, that says, okay, there was admitted negligence by one of the defendants, yet the court upheld a comparative negligence that had 0% assigned to that person?
I'm not aware of that, Your Honor, but I do know that the jury does not have to accept even unrebutted expert testimony that it was someone's fault. The jury does not have to accept someone's opinion that it was their fault because she liked their coffee. And that's what happened in this case. There is one case that I would like to discuss, which is akin. There's not a case on point, Your Honor, that I'm aware of. There is a case akin, which is the Levy versus Home Depot case. It's a 3rd DCA 1987, in which they quote Prosser and Keaton on torts when they talk about when there's a condition in which someone may have their arms full of bundles, it may be anticipated that the visitor will not be looking for a hazard. That's akin to this case. Starbucks placed that coffee and placed that biscuit in her hand, knowing that she would be distracted pulling out of the drive-thru. At the same time, Starbucks made the decision to put exiting pedestrians into that blind corner where this happened. So a jury could hold that a woman with arms full of bundles walking on a sidewalk is not responsible for tripping over a 3-inch hazard on the sidewalk. It is foreseeable that this person would be putting her receipt in her purse and eating her biscuit or taking a sip of her coffee for 1 second. And the jury can decide it's not her fault. She's not negligent for causing this. It was Starbucks who set the trap for these two people, two victims in this case, to fall into. My argument, ladies and gentlemen of the jury, you can assign 0%, you can assign 5%, but that's your job. It's not the government's job, it's not the judge's job, it's the jury's job under our Constitution.
What about the empty chair argument not being permitted?
I'm sorry, say again, Your Honor?
What about the empty chair argument not being permitted?
Well, it was permitted. It was never prohibited. In fact, you can see it in their argument.
Well, I did see in their argument, and I would agree with their characterization, that they came about as close to it as you could without getting whacked with a gavel. So they got a lot of benefit from it, but when you settled with the landlord on Sunday afternoon before Monday starting up, and then you claimed you were prejudiced, I think they might have had the same claim that they were surprised or at least prejudiced. But why couldn't they argue empty chair? I mean, I don't think it would have been successful because it's an all or nothing deal, and I think probably after the evidence, I'm not sure it would be successful, but why weren't they at least allowed to give it the old college try?
Number one, Your Honor, they did, and they were allowed to. The court never prohibited them from doing so. The court said you have a duty, that is a matter of law. That was the only ruling.
The court said it was too late and too cute.
Too late, too cute to argue they didn't have a duty.
Too late and too cute to argue empty chair.
Your Honor, I believe that was not on the empty chair issue. It was, in fact, on them trying to argue they didn't have a duty in this case. In fact, we know that the court didn't rule on the empty chair because he didn't shut them down when they made that argument in closing, and we did not object. They never put these people as Fabre defendants.
Page 617, the court, this is all too cute. How could it be? We're here, plaintiff had known there would be this quote-unquote empty chair defense. There have been alterations to the presentation of evidence. So it most certainly was about the empty chair, and they were not permitted to make a full-blown empty chair. Again, I agree. I don't think it would have been successful since it's all or nothing, but how can they be prevented from that? The case law is clear. A general denial, which they made among other things, a general denial is all you need to make the empty chair argument, right?
Well, not necessarily. They have conflated the duty issue into an empty chair to try to create an empty chair appeal. What is the empty chair? I think we need to address that. The empty chair rule is that when a non-party is alleged to be the sole cause of the injury at issue, the sole cause. What was Starbucks Corporation's opening statement? There are two people who caused this, an inattentive driver and an inattentive pedestrian. We're not talking sole cause. That is their opening statement. Those were their five defenses. If you're going to allege sole cause, you have to have sole cause of the injury at issue. This is not the Vila versus Philip Morris case, in which they put into evidence that the man who was addicted to cigarettes got addicted in foreign countries made by cigarette makers that were not Philip Morris. And they put that evidence into the record, and then they were prohibited from arguing empty chair. This is not the USF case versus Carter, in which they wanted to put into evidence the testimony of the expert that said the sole cause of this injury was the failure to give antibiotics by the critical care team. They are prohibited from putting in that evidence to prove the sole cause. This is not a sole cause argument. They were blaming everybody else, and then at the last minute, they wanted to utter the magic words of empty chair, which is not what the law allows. The law allows, if you're going to argue a sole cause, that's empty chair. They didn't do that here. They wanted their cake, they wanted to eat it too, and they wanted a free bite at the apple. And that's not what the law is. If that's the law, all they have to do is utter empty chair at the end of every case, and we'll never have finality. In this case, they were not prevented from putting one iota of evidence in, not once. In the USF versus Carter case, they were prevented from putting in that expert testimony that the failure to administer antibiotics was the sole cause. In the Philip Morris case, they were not allowed to argue empty chair because the court didn't think, I don't like that argument. This isn't that case. No evidence was prevented from coming in. There's not an iota evidence that someone else was a sole cause. In fact, this drive-through was the exclusive possession of Starbucks Corporation. It's under the lease. They had control over it, and absolute control. This is not some outside party. So, Your Honor, I don't think the empty chair is a valid argument, and I don't think that they thought they were prohibited from arguing it, because they did in closing argument. We didn't object, and the court didn't shut them down. So in closing, I'm not going to take up all my time. The trial court properly precluded Starbucks Corporation from confusing the jury on its duties under Florida law. That is a question of law for the court, not for the jury, under the guise of inapplicable, last-minute, empty chair argument. Indeed, to conclude otherwise would create an untenable rule. The empty chair defense would become magic words that, no matter when uttered, up to and including the last day of trial, would entitle the defendant to a do-over if they are unhappy with the verdict. That is not and cannot be the law. Thank you.
All right, thank you.
I'd like to spend my remaining time addressing the empty chair as well, but before I do, I want to go back to one point as it relates to the duty owed by the landlord versus the tenant, and one distinction that I think is significant, which is that in the cases cited by Gold, which include the Levy case versus Home Depot and the Burton case, and specifically Levy, because Levy says that the holding or the analysis in Federated was not applicable. And when it said it was not applicable, it said it was not applicable because Home Depot, the Levy case, involved a static condition. And that static condition was an uneven or a 10-inch gap in the sidewalk. And similarly, Burton involved an elevated divider in the parking lot. Static conditions. There was nothing static about the conditions at Starbucks that were involved in this accident, and that is why the holding of Federated and Jeffrey apply in this case instead of Levy and Burton. This case is anything but static. It involved motion by multiple parties, Ms. Gold as the pedestrian, Ms. Ward as the driver, moving around in her vehicle and obviously a moving vehicle. And so, again, based on all that movement and the lack of a static condition, that is why those cases are not applicable.
Quick question, if there hadn't been a settlement on the Sunday before trial, what would the verdict form have looked like? Wouldn't it have been apportioning negligence among the defendants?
Absolutely, Your Honor. It would have been any comparative on Gold and then Island Walk Station as the landlord.
So this can't be unusual where someone settles and there's multiple defendants. I mean, typically I would think that there's an ability of the plaintiff to argue at least some of the negligence of the settling defendant contributed.
Yeah, agreed. And I don't think it is. I mean, I think even the Levy case, if you look at that, there was a settlement of the landlord prior to that, and it left the tenant hanging out there. And so again, to move toward the empty chair defense and the argument, yeah, I think that was exactly the question, Your Honor. I mean, here we are Sunday afternoon before trial. The landlord is now out of things, and so the question is, do we name them as a fabre based on an alleged shared duty, or do we attempt to empty chair them based on the fact that under the lease, they are responsible for the common areas, which include the parking lot where this accident happened? And so to the point of what was required and what occurred, I think the context and the timeline of that is important too, because the first notion to the plaintiff that we intended to pursue an empty chair was not after the close of their case. We talked about it early on in the trial, and the trial court was the one who said, I can shut that down via motion in limine. But despite saying that, the case proceeded all the way through plaintiff's case, and there was no motion in limine filed until that Sunday after they had closed their case and Starbucks was to start their case. And that motion in limine, again, erroneously stated Florida law as to the landlord's duty in a situation like this, given that there was no static condition. But beyond that, again, we had satisfied all the prerequisites for that empty chair. And so when the court initially granted the motion and said, do you have counsel, do you have anything that says she, referring to me, can't do what she's doing? The response was no, just that it had not been pled as an affirmative defense. We readily responded to that, saying an affirmative defense is not required, it's just a general denial. And the court on its own came up with a prejudice argument. It was never argued by plaintiff that they were prejudiced, and to the contrary, they had been or should have been expecting us to assign fault in some context to the landlord. So it wasn't just, a suggestion of magic words or that, that was an easy out for us after the fact. There was always an intention that Starbucks would split whatever liability came its way with the landlord because of that arrangement. There
were no cross claims, were there?
There was not, Your Honor. Obviously, the lease provided for the potential for indemnification, but there were no cross claims. But there was always the potential that they would share whatever liability, however that looked, whether it was all parties listed on the verdict form or through the assertion of an empty chair defense. And in this case, Starbucks was wrongfully precluded from pursuing that defense. And again, as close as the line as we could, but certainly not the full extent of what we would have argued and alleged had we been able to present that empty chair defense. Thank you, Your Honors.
Thank you. Well briefed and well argued. Thank you both.
Take a break after the second case. We'll see.
Drive safely. Wish us that day after tomorrow. We make y'all come down here, then we're going back up there, so.
Yes, sir. Thank you very much.
Yes. All right, everybody ready? Okay, we'll have our second case of the morning, which is Lazaroff versus Meek, case number 2319. And again, let me know if you want something other than 5 minutes for a rebuttal.
Thank you, Judge. My name is Warren Kwobnik. May it please the court. I'd like to reserve 5 minutes, please, for rebuttal.
Okay.
Again, I'm Warren Kwobnik. I represent the defendant appellant in this case, Justin Lazaroff. I know that when I come before the court on an appeal like this, I am facing a number of burdens. One is first impressions. I assume that one of the first things this court does is it looks at the order on appeal, and the 12-page order in this case is harsh. The other burden that I have in this case, I know, is a presumption of correctness and a deferential standard of review. In response to all those things, however, is that an order that grants new trial has to state its grounds, and those grounds must be supported by the record and the law, and this is where this order fails in large part, if not completely. And briefly to roadmap it for the court, there was no age-related theme designed to show that Medicare would pay the plaintiff's future medical expenses. The one and only...
In a case like this, they were seeking only future damages, correct?
Correct.
Okay, and where you're talking about future loss of earnings or future loss of income, however it's phrased, you want to know how long plaintiff intended to work, but for being injured, whether that was realistic to work that long, and that evidence came out, correct?
Yes.
In fact, it was plaintiff's counsel who first asked the vocational rehab, Bradford, was that her name?
Correct, Judge.
Plaintiff's counsel had that discussion first with Ms. Bradford about how long did he expect to work, correct?
Correct.
And her answer was basically 65, maybe up to 67, and when you start talking 69, that's maybe a little long, correct?
Yes, Judge.
And then defense counsel repeated the same questions, right?
Yes.
Okay, and no objections?
No, and why would there be? Age was inherent in many facets of the case. As Your Honor points out, it was relevant in large part to the future earning capacity, how long the plaintiff might work, when he might retire. These things are unremovable from the case. In addition, it was uncontradicted that the plaintiff had pre-existing age-related conditions that, of course, the parties got into. Age was brought up just as much by the plaintiff as it was by the defendant, and not for any improper reason. It was part of the case. And with regard to the future medical expenses, plaintiff had Dr. Leber prepare a life care plan 2 years prior to trial, and one of the points that my opponent is pointing to relates to that. One of Dr. Leber's recommendations was that when plaintiff turned 65, that was an age-specific thing in his plan, the plaintiff would begin psychological testing. So one of the questions asked of Dr. Leber by the defense is, well, you made this plan 2 years ago. It called for plaintiff to begin psychological testing at 65. Has he started yet? That's unobjected to, of course, but it's a completely appropriate response for a number of reasons. One, it goes to why isn't the plaintiff doing the things he's supposed to be doing, which was our mitigation of damages defense, and also it discredits the life care plan. The plaintiff is here asking the jury to award between $400,000 and $500,000 based on this life care plan. The plaintiff hasn't started doing the things he's supposed to be doing. It discredits the plan. So
the defense counsel didn't merely talk about age 65. He talked about 2 years into the plan, supposed to be doing A. Has he done A yet? And Lieber basically, for all the questions, said he didn't know, correct?
Correct. Not all of the recommendations were tied to a specific age. This one was, which is why the age 65 was mentioned. But there were a number of things that in some...
Appellees raised the fact that Social Security came up at some point that, I'm not sure exactly what the phrase is, but basically defense lured them into saying Social Security. It was again plaintiff's expert responded to that, brought that up, correct?
Correct. It relates to the first time Your Honor referenced on the cross-examination of Andrea Bradford. Defense counsel said, and in terms of how much longer he might be expected to work, and 67 is, a reasonable retirement age, and she said, yes, Social Security calls for that. So that was something volunteered by the plaintiff's expert. And again, Social Security is not Medicare anyway, and that wasn't the subject of but
did plaintiff's counsel then on redirect ask Ms. Bradford about basically Social Security and receiving government benefits?
I don't recall, Judge. I'm sorry. I prepared as best I can. I don't remember that question. I'm sorry. But everything up to this point, I agree completely. That's the way it played out. The big picture is when the judge finds that there was an age-related theme intended by the defense to show the plaintiff would collect Medicare, no, that's completely untrue based on the record. So when we remove that age-related theme that doesn't exist, what are we left with? We're left with a singular, unfinished question about who's the largest provider of health care services. And that's not a collateral source question, and it would not have been a collateral source question. We know from the case law, we've cited in our brief the case of Anheuser-Busch versus Reese from the First District, this court's decision in Lumbermans versus Polling. These cases say that references to a collateral source payor, or even references to a collateral source itself, is not improper, and it should be allowed when it goes to something pertinent. Here, it went to whether Dr. Leber's costs were reasonable, which the defense absolutely has the right to contest. What Dr. Leber did in making his life care plan is he looked at a database, and it's like a menu, I imagine, and he pulled up the costs, and we think those costs were very inflated. So it's not a collateral source question to say to Dr. Leber, well, when you looked in your database and you pulled these numbers and you plugged them into your plan, did you consider what the largest purchaser of healthcare services might pay for these things? That doesn't say that the plaintiff is going to collect Medicare or that he's eligible for Medicare. It's, did you consider what in fact is paid for in deciding the reasonableness of the costs? That inquiry didn't even get completed, but it would not have violated the collateral source rule, and we've cited some out-of-state cases to support that that's the case. But again, we don't have to go out of state. If you look again at the Reese case and the Polling case, that demonstrates that the mere mention of the word Medicare is not collateral source evidence. The other thing, too, along those lines is, in the context of the case, we're talking about a 9-day trial where the jury heard a lot of evidence, and I detailed it in my brief, not because this appeal is specifically about the evidence, but to demonstrate to the court that there's no reasonable determination that these incidents are what caused the jury to return the verdict that they did. Over a course of a 9-day trial, the jury heard evidence that largely discredited and dismantled this case on the merits. Every claim that the plaintiff had was shown to be weak at best. That's why the jury returned what they returned. But in terms of...
Did plaintiff have pre-existing conditions, accidents, injuries?
Yes. Yeah, he had...
And was that explained to the jury?
Oh, yes.
And if the jury believed those, would that have supported, not necessarily compelled, but supported the verdict that was rendered?
Yes. Yeah. I mean, he was claiming injury to his low back. He had chronic pain with pain going out into his leg, reported in the medical records of, I think, a week and a half before our accident. His level of pain before the accident was reported to be basically the same level it was afterward. He was a truck driver. The use of his knee was a well-known stressor. And he had, everyone agreed, he had arthritic conditions in his knee. With regard to his brain injury claim, that too was based on a claim of unconsciousness that was all over the place and uncorroborated. At the same time, we know that the records indicate it's at least 2 prior instances related to an unconsciousness or a brain injury, all of which the plaintiff denied when confronted with medical records. He doesn't know how the unfavorable things wound up in his records. So yes, it was a largely discredited case. That's why the jury returned what they returned, not because there was a half-finished inquiry about who's the largest purchaser of medical services. Again,
is it appropriate under the Florida Evidence Code to ask an expert what the basis of his opinion is?
of course.
And is it proper to do that with a leading question?
I'm not a trial attorney. I understand that the way you ask a leading question is with a statement and then, isn't it true, or isn't it true that, or, it's raining out, isn't it? It's a statement finished with that. And in fact, if you look at the way this examination proceeded, defense counsel tried to ask it in a non-leading way. Who's the largest purchaser of medical services? And Dr. Leber said he didn't understand the question. So then it moved on to an appropriate leading question, which never got finished, and the judge decided that all of this was part of a scheme to suggest that Medicare was going to pay, which is...
Let's talk real quickly, if we can, about the 2013 CT scan bill.
Yeah.
With Meeks versus Meek, and
Yeah.
I mean, was there evidence in the record to suggest that he had prior head injuries for which this scan could have been done?
Of course.
But y'all didn't have an evidentiary basis really to get that record in?
We were not in possession. It's a 2013 scan. We don't have the scan itself. And the way that played out, the court is apparently familiar with it. In the course of discovery, we subpoenaed from the radiology service that read the films, in this case, the records. We got an invoice, and it had on the invoice pre-accident scans having been read as well for Mr. Meek or Mr. Meeks. We don't have the films themselves. That invoice the authenticity was stipulated to. The plaintiff had it at all times. It's mentioned in opening in a completely accurate way. We have an invoice that shows that he underwent a brain scan in 2013.
Was there an objection in opening?
Zero objection to that. And beyond that, the invoice was addressed, and the 2013 scan was addressed by both sides, I think with Dr. Boehm, with Dr. Boehm responding to a question by plaintiff's counsel by saying that 2013 scan was normal, when they went on to say that it didn't even pertain to him. And then mid-trial, plaintiff's counsel tells the judge, it's not our client's scan, because if you look at the top, it says Meeks, not Meek. The address was the same. It was plaintiff's. The other entries on the same invoice, no one says were not the plaintiff's, but because it said Meeks and not Meek, as many medical records do in this case.
Pointed out in your brief, several different healthcare providers referred to him as Meeks with an S on the end, correct?
Sure, I'm sure that happens to Mr. Meek frequently.
Was there any proof that it was not Mr. Meek's bill?
No, it was a belief, and I think plaintiff's counsel even expressed it as a belief. I believe that they combined the charges with a different person whose name is Mr. Meeks. And
let's talk about seatbelts. The court points out that y'all brought up seatbelts. Was it plaintiff's counsel who first brought up seatbelts? Actually, was it Captain Mack who volunteered seatbelts?
It was very good. Yes, Captain Mack did bring up seatbelts, and plaintiff's counsel asked some follow-up questions about that. How do you know he's wearing a seatbelt? And again, it was brought up on cross, again, by the defense, and the objection at the time, if I recall, was beyond the scope, and that was sustained. No motion for mistrial. But again, when you start getting into those miscellaneous things, I'll call them in the order, the seatbelt was really not one of the grounds for the mistrial. That was among some other, I don't want to call them throwaway points, but miscellaneous things that I think were there, mentioned at the beginning of the order, not really a ground for relief. And I think the way the order closes is by saying, for these reasons, based on the Medicare issue and the concealing evidence issue, a mistrial is needed, and especially due to these other things.
Well, concealing evidence, let's talk about that then.
Yeah, that's...
Again, the court found that y'all were making basically unfair comment on his recitation of his medical history. Is that correct?
Yes, and more specific than that. The court found that it was a missing witness adverse inference argument, which in many cases you can't say, hey, because they didn't present a certain doctor, you should infer that that person would have said something unfavorable to them.
Your argument, or counsel's argument at trial was, plaintiff said, we brought you the treating doctors, and his counter to that was intended to be, yeah, well, you brought 3 out of 10, right?
That's part of it. First of all, it was not a missing witness argument at all. It was obviously a response. On its face, it was a response to what was just said. Plaintiff's counsel said, we brought you the treating doctors, the people who care about him, the people who treat him. They don't have a dog in this fight. They brought you retained experts. Two things very misleading about this. They didn't bring the treating doctors. They brought 3 out of about 10. And of the 8 medical witnesses they brought, 5 were litigation retained experts. So it's completely misleading to suggest that everyone we brought you here is a treater who just cares about this man and is not.
Plaintiff said, we brought you the treaters, defendants bring hired guns, basically.
Yes, and...
nicer than that, but basically.
Essentially, yes. And defense, I think it was appropriate, a fair response to say that's not quite accurate, but he didn't even really make the argument. He got so far as listing some of the uncalled treaters, and then the judge, it was truncated, and the judge gave a very harsh, what the judge himself called a punitive instruction, basically saying defense counsel had done wrong. Struck it and gave a curative, and in fact there was a curative for the Medicare issue also. So yes, that's the way that played out, and really those are the grounds for the new trial order in this case. And I think as we go through them, with Judge Edward, you taking me through the issues you want, I think that covers it. And I think my position is that none of these grounds are supported in the record or in the law, and certainly none of them collectively or independently warranted setting aside this jury verdict.
There was an objection about the missing witness issue or argument, right?
There was an objection to that.
And once the judge raised the Medicare issue, plaintiffs then vehemently objected and moved to for mistrial, right?
Well, they did, and I think that ties into another point. One of the miscellaneous points in the new trial order is that there were just so many reasons to object in this case that the mere fact of the objections is part of what requires a new trial. But if you look at the grounds that were actually for the new trial, there was no objection to the 2013 scan. There was no objection to the Medicare. There was no objection to an age-related theme during the trial. So whatever objections are being referred to are not the primary grounds for the mistrial. These are things that either weren't issues at all during the trial or were the judge sua sponte dealing with them. I don't know if I'm in my rebuttal time.
You are into your rebuttal.
Okay, then I'll reserve the rest, if I may. Thank you.
May it please the Court, Rebecca Creed on behalf of the plaintiff appellee. We ask this Court to affirm the trial court's well-reasoned and well-supported order. There is no abuse of discretion that is patent from this record. The trial court followed the correct law and reasoned, based on its discretion, that the prejudicial misconduct of defense counsel warranted a new trial.
Let's talk about the theme of age. You agree that age was a relevant factor in this case, correct?
Yes, and the trial court recognized that as well.
The plaintiff was the one who started out asking about age, and defense, at least in first with Ms. Bradford, the questions were very much the same, weren't they?
The questions were the same. The difference was, and the trial court, I would point out, also recognized that age is obviously appropriate to be referred to for certain factors and considerations. On page 1692 of the trial transcript, fair game, the length of the life care plan is this because his life is that. What the trial court was concerned about was the statement that was an intentional interjection of Medicare and a description as the largest purchaser.
Did not interject that, did they? You're talking about the Medicare.
Medicare
okay, sorry,
comment.
yeah, Medicare.
Yes, the Medicare comment, unsolicited at the end of his closing, or excuse me, of his cross-examination, which the trial court considered was, based on the record, an attempt to really draw emphasis to that.
Does the judge have a crystal ball to know how that half-asked question would have been finished?
Well, he had enough to know that the statement was unsolicited based on nothing in this case, essentially defense counsel's testimony that Medicare is the largest purchaser of health care products and services.
It's a leading question. Counsel can make any leading question and the witness can agree or disagree, correct?
But in this case, there's nothing to tie, there was nothing to show that Dr. Lieber used a Medicare pricing index in his formulation.
Perhaps that was the point of the question.
But there was nothing in his plan to suggest that. He had testified to the basis, his database.
Right, but you're entitled to ask an expert, why didn't you consider A, B, and C, aren't you?
Which he did ask who's the largest purchaser, but at that point in time, there was nothing to tie or to suggest that Medicare was the largest purchaser, but for defense counsel's comment, and he admits that he based that question on a 2016 report from another expert in another case entirely. The trial court recognized that there were ways that defense counsel could have gotten at the information that he was seeking, which was more along the lines of what he claimed was an inquiry into the basis for the opinions, but that wasn't the question asked, and there was no foundation. And what the trial court heard.
If Dr. Lieber if the question went out that is Medicare the largest purchaser and did you consider them, compound I understand, and Lieber said, yes, I understand they're the biggest purchaser, no, I didn't consider them. If the question had been asked more properly, more cleanly, would it have been appropriate, or do you say no?
I think the interjection of Medicare was so prejudicial in this case, as the trial court found, because it wasn't simply, it was asked in a way that the trial court considered it to be a suggestion or an inference that this plaintiff, at his age, the jury knew how old he was, would be entitled to benefits in the future, would have future Medicare benefits, and so why should the jury worry about awarding future damages or damages for future medical expenses?
The defense counsel didn't say that at all, did he?
He did not say that, but he did interject Medicare, and he did.
Medicare is used as an index for benefits, isn't it, under the PIP statute? I mean, an insurer can index payments at 200% of what Medicare pays, and it's all throughout that statute, correct?
There are contexts, and there are cases, and the defense cites them where Medicare is permissible, but those aren't the facts of this case in the way that this argument was raised.
What about, there's comments that age 65 was a theme throughout.
Yes, and
The only thing, I mean, we've had our discussion here. I mean, again, the age at which he was going to retire, was that reasonable for his future loss of earnings? You agree that that's a legitimate line of questioning for both plaintiff and defense, correct?
yes, except to the extent that what is happening here and what the trial court found was this was an attempt to question age and tie age to future Medicare eligibility. And I would submit that Medicare...
And so you also complain or say that he...
Yes.
And I don't remember exactly the word, so pardon me if I get it wrong, but that defense counsel basically got whatever Ms. Bradford to utter the word Social Security, that it was his questioning that got that out
Yes.
there. But he, in fact, did not say Social Security. If he was trying to be a good boy and not say Social Security, he just asked about the normal retirement age being 67, right? And Bradford brought up that it was Social Security, right?
I believe I would have to look at the exact testimony.
And then it was actually plaintiff's counsel who brought up the fact that and it was Mr. Blanco, asked Ms. Bradford, is it proper to consider invoke rehab any age by which the government says somebody's going to receive benefits and cut off earning? So plaintiff brought up the fact that there were Social Security benefits available once you reached retirement age, not defense, right?
Yes, but there was an effort to tie the age to the Medicare comment. And
I'm talking Social Security. I understand I understand your Medicare argument.
Well, the Social Security reference wasn't an independent ground for the mistrial, and the issue as to the age-related theme was considered by the trial court in conjunction with the Medicare comment.
And the other part of the theme was what? His fiancée, who is quite a bit younger, I don't remember exactly how much younger, but she talked about how his behavior or his interest had changed and weren't the same as hers, basically, correct?
Yes.
And defense pointed out the age difference?
Yes, and again, we're not raising the intention was not to raise age as an independent ground for mistrial, but it was the age in conjunction with the Medicare comment that the trial court was concerned, and the trial court was in the best position to view the impact of that
Basically,
testimony.
what you're saying, what the trial court said, was that a half-asked question that included the word Medicare in it, that's really what drove the mistrial, correct?
That's one ground for the mistrial. The missing witness, excuse me, commentary is another. But yes, it's the Medicare, as the trial court found. We're inserting Medicare into it in a way, so it's an implication. Don't worry about this so much because he's going to get Medicare in the future anyway.
If he had said that, I agree that would have been horrible and a mistrial and sanctions and all the rest of it. That's not what was said, though. That's the judge with the crystal ball and plaintiff's counsel with the crystal ball putting words in defense counsel's mouth, right?
But what defense counsel started out with was just a statement that was an intentional effort to draw the jury's attention to the existence of Medicare and a description that is not supported anywhere in Dr. Lieber's testimony or anywhere in the evidence of this case as to Medicare as the largest purchaser of health care services.
Defense counsel would have had to have been kind of slow to bring that up with any of its experts, wouldn't it? After being chewed out by the judge for 20 or 30 pages to ask one of his experts?
Well, they didn't call a life care planning expert to refute Dr. Lieber. And so there are circumstances when it may be appropriate to reference third-party payers or average rates, but that wasn't what occurred here.
And totally relevant to say, did you take into account what health insurers pay for this surgery, correct? Because wasn't the evidence that Dr. Lieber estimated the cost of one surgery at around 130 or 150,000, and the treating surgeon had said more like 75 or 80? I mean, there's a pretty big
That
gap,
evidence
right?
came in, yes, yes.
So it would have been proper to ask, what else did you consider? He said he looked at the database that's the largest of its kind. Would it be a fair question to ask, did your database include what health insurers pay, what Medicare pays, what people, who have no money pay?
It could have been, and again, that's the trial court recognized that there could have been a foundation laid that got to this information, and the cases cited, the federal cases, illustrate that. But that's not, again, what we have here. I would like to turn to the comment on the missing witnesses. That, again, was another factor, another ground for mistrial. Oh, and one more point on the Medicare. While the trial court sua sponte basically stopped the questioning on the Medicare, we did move to strike that testimony or move to strike that comment, ask for a curative, and move for mistrial. So we did preserve that. Excuse me. On the missing witnesses, this was a comment during closing, which was 4 days after the comment on Medicare, and it was purportedly in response to plaintiff's counsel's closing argument that we brought you the treating doctors. They have a doctor-patient relationship. The defense has brought you retained experts.
I mean, that was the argument that was made, right, by plaintiff's counsel?
That was the argument that was made. There was no reference to, we brought you every treating physician, we brought you all treating physicians, we brought you only treating physicians. And defense counsel responded to that at the beginning, the outset of his closing argument, the substance of his closing argument. There's something the plaintiff's lawyer said during his opening that caught my ear. He said, we brought you the treating doctors. He then proceeds to list the 7 by name, the 7 treating physicians who were not called as witnesses here. And that is a violation of the trial court's order on closing argument, as the trial court found, and it was an attempt to comment on the failure of the plaintiff to call each of those treating physicians. It's not just a failure to call, it's
that there would be an inference that their testimony was bad for plaintiff, correct? I mean, that's the whole idea behind not permitting the missing witness argument?
That's the idea behind it, but under
When the
Louder...
plaintiff gets up there and brags, we brought you the treating doctors.
But he
it's not
doesn't...
fair to say, well, they brought you some of them.
But not to list those specific ones that everyone knew had not been called.
Well, could you have, I mean, would it have been a legitimate argument to say, well, they brought you some of them, but not all?
He could have said, no, I don't believe so, but I do think there's more harm.
He just has to basically not respond to that argument.
No, he could have said the plaintiff points to the treating physicians as being more credible or more knowledgeable. I could point out that, and I think defense counsel did point out, that the plaintiff also brought you litigation-retained experts. That was okay, but to specifically name the 7 treating physicians immediately following a comment that the plaintiff says we brought you the treating physicians, the treating doctors, and to list those 7 by name that were not brought, that everyone knew had not been called as witnesses at trial.
Was there an order on that, a pretrial order?
There was a pretrial order.
So they were violating the pretrial order.
They did violate the pretrial order because they didn't seek they didn't seek permission to raise this advanced witness inference. And the standard is not simply that at that point you had to show what that inference or that the
Counsel,
testimony would be adverse.
What is in my mind on this case is more of a process question, because I rarely see where a trial judge will sort of jump in and grant a new trial without there having been some warnings and preconditions and motions in limine and pretrial orders being violated. So here, was there any motions in limine that were made that were seeking to preclude this sort of testimony that you're complaining about?
No, there was not a motion in limine. There was the order on closing argument that set forth and cited the Louder case, which states that when witnesses are equally available to both parties, no inference should be drawn or comments made on the failure of either party to call the witness.
And just, I'm sorry to interrupt, but again, the motion in limine question I was getting at, as to any of the categories of information that are prejudicial. In other words, the Medicare. Was there any motions in limine as to any of that?
Not that I recall as to any of those
So I
specific
guess what I'm
categories.
getting at is, I'm putting myself in the, I'm sitting with two trial judges, and I wasn't. So I'm putting myself in the trial judge's seat and trying to figure out what was in this trial judge's mind. And it seems to me that he was getting agitated about certain things that you weren't complaining about, at least in a motion in limine, that they just sort of came up at trial. The Jorg issue, the Medicare issue, I could see where, if that was going to be a feature of the trial, you might have moved in limine to prevent it. So I'm just trying to get a sense of where this trial judge was coming from to take this pretty significant action to grant a new trial, when there really weren't any sort of warnings being made early on.
I would disagree. I think there were warnings that were made throughout the trial. You can start by looking at the Medicare commentary on what the trial court viewed as improper attempts to bring in finances. That wasn't a ground for the mistrial that was ultimately granted, and I believe it was in part and parcel because of defense counsel's responses, quite honestly, to when objections were made and sustained and a motion for mistrial was made. On the missing witness, there was a standing order on closing arguments. The trial court had brought counsel's attention to that standing order many times during trial. It reminded them the defense.
That particular one is paragraph 24 that says, counsel shall not urge the jury to draw an adverse inference from the failure of the opposing party to call a non-party witness unless a proper showing has first been made with the court. So it's not to not comment on it, but to not urge the jury to draw an adverse inference, correct? I mean, that's what the order says,
That's
right?
what the order says, but it cites to the Louder case, which says no inference should be drawn or comments made on the failure of either party to call the witness. And even aside from that, there was no advance motion. There was no, although the defense sought leave to argue another issue in closing, he never brought up the fact that he intended to make this treating physician, absence of treating physician statement. And he could have.
The court commended defense counsel for being so candid in raising one of the issues that he thought about bringing up, correct? Saying,
Yes,
this is really done great, you avoided a big problem during closing by bringing this other issue up. And you're not allowed to talk about it, and he didn't, right?
Correct, but he could have done that equally with the treating physician statement. The defense knew before closing that not all 10 of the treating physicians had been called. And importantly, I would point out that the defense counsel, when questioned about this, he admits that basically his intent was to talk about. Plaintiff's counsel told you he'd presented the treating physicians, he did not. I'm pointing out he didn't. That dovetails with the representations both in closing and in argument and opening that they're going to show you the good, the bad, and the ugly. So the inference was that the defense wanted to respond to this in some belief that we had argued that we were going to bring only treating physicians, to point out the ones that weren't called, and to show the jury effectively that the plaintiff had in fact not shown the jury the good, the bad, and the ugly, that it was hiding evidence and it was not being forthcoming. And given that the credibility of this plaintiff was an issue throughout trial, the implication that the plaintiff and his counsel were hiding evidence or were not fully disclosing information was particularly harmful and prejudicial.
What if the plaintiff's argument would have been, we brought you all of the treating physicians? I realize that's not what was said, but then would it be fair to say, well, wait a minute, you didn't bring these treating physicians?
I think that would have been
So
okay
what
to
if they
say.
interpreted, or the argument the plaintiff did make was capable of being interpreted that way, and defense just wanted to clarify that?
But that's not, well, that wasn't the argument that was made. The argument by plaintiff's counsel was not, we brought you all the treating physicians. And in fact, in his closing argument, plaintiff's counsel specifically references the testimony and summarizes the testimony of the experts who had testified at length that they didn't have a patient-provider relationship.
You agree that the seatbelts was not a basis for the mistrial, correct?
Correct.
And the reference to the 2013 CT scan, for which there was no objection, that was not a basis for the mistrial, correct?
It was considered as another example of it could be considered and
All right, well,
was
in the
set forth.
2013 CT scan bill, was there an objection raised to that?
Not to the opening statement. There were objections made to the admissibility of the invoice that showed those.
Later on, but
We-
when Dr. Beam or Baum, however you say his name, he was questioned about that as well, correct? By plaintiff's counsel.
Yes, but
So the jury already heard about the 2013 CT scan without objection and no motion for mistrial, right?
there was not a motion for mistrial directed to the 2013
Later on,
opening
when the defense
statement.
tried to put the bill in, they didn't have an evidentiary
Correct.
basis,
And
but
the defense admitted at that point that.
they couldn't get it admitted into
They
evidence.
couldn't get it admitted into evidence because he had no record of
But
the
it wasn't
2013
fiction
and no
in
witness to
terms-
tie.
Ma'am,
Excuse me,
in
sorry.
terms of plaintiff's counsel represented that Meeks was not their client, even though it was the same address, the other treatment was the same, and at least three other healthcare providers referred to Mr. Meek as Mr. Meeks with an S on the end. He had no reason to know that was or wasn't. He believed that, and I think honestly believed it, but he had no evidence to show it was not the client's bill either, correct?
Correct. It was the defense exhibit, and I would argue they had the burden of showing admissibility. We would ask this court to affirm, and based on the cumulative misconduct and the instances of misconduct. Thank you.
Thank you.
I think the court understands my position, but I would like to make sure I address any questions that the court has.
Were there any curative instructions given as to the statements?
Yes, curative instructions were given after the Medicare reference, and a curative instruction was given after the closing argument. Yes, so yes, they were.
So they addressed the Medicare and the...
Yes, yes. The Medicare, the unfinished Medicare question, there was the lengthy sidebar, and then the jury was given an instruction that it's stricken, and they were given a collateral source instruction to the effect that you shouldn't reduce your verdict by governmental benefits. The court will do it as necessary. And then with regard to the closing argument, which of course I maintain is not a missing witness adverse inference argument, the judge gave a curative instruction that was particularly harsh. The judge knew, I mean, he said it's punitive, but he gave it anyway. And he said, the instruction violates the rule that you can't draw an adverse inference, you should disregard it, and it was improper, basically. So yes, there was in no uncertain terms curative instructions given for these things. If there's no other questions, I would ask that the court reverse and reinstate the jury verdict. Thank you.
Thank you. Again, well briefed, well argued. Thank you both. Keep rolling?
I could use 5 minutes.
Okay, we're going to be in recess for about 10 minutes.
that, you win. And after that, I was like, all right, I mean, it doesn't mean anything. And so,
It's true. You know, I mean, I think more often than not, you have a pretty good feel. I think.
you do, but you hope, you know.
I had one with Rebecca about 6 months ago, and I got a boss completely.
Yeah.
And it was the weirdest decision that came up. But yeah, you don't know. Yeah, when you get hammered, it's like, you know, I remember that one. I was at the first DCM and drove to Lauderdale. So it was like an 8-hour drive home. And going along, you thought,
Yeah, after you think you just,
yeah. Well, and of course, and no matter how long, the second guessing always begins.
nah, I should have said this. I did, something that really helped me was, yeah, it must have been 10 years ago now. I was at a Duval County, they had a couple of first DCA judges in, and I forget who it was, but one of them, he was pretty high up, he wasn't the senior judge, but he was like very high up. And we were talking about oral arguments and the importance of them. And the guy who was moderating basically said, well, I have 3 appellate judges right here. And it was like from the first, second up from the first. And he said, can you tell me, how many times you read an oral argument and oral argument actually changed
What a great question.
how you ruled ultimately, or changed your mind about something, right? And the most senior judge, he goes, I don't know about them two. He goes, and he raised his hand. He says, that's about as many times.
I can
change
change
my
that.
hand. And he says, there, and he goes, and I've probably heard hundreds of them. So, and then the other ones were kind of nodding their heads too. So I think argument is mainly for them to maybe get their positions and or maybe solidify, maybe
Who knows?
ask, if there truly is like, factually, let me see.
Well, let me ask you, in your oral arguments,
Right.
did you ever get a sense that by the end, minds might have been changed one way or the other?
No. I have been in some where I've said something, or frankly their side has said something, and the judge kind of sits there and like, oh, okay, I understand. Maybe it was more of a, I don't quite understand your argument, and now I do.
Okay, well,
And then, all right, fine, but I never
didn't change anyone's mind.
I never got a sense that it was like, which I think just sort of took the pressure off of me. It's like, I don't have to be like,
well, you see, that like
fantastic and oral.
I'm preparing for 2 oral arguments today. It's like,
That's crazy.
yeah, but one of the things that keeps me calm is design.
Yeah, right. And all I'm doing is just making a fool of myself, or especially online. So it's and obviously I always want to be straight with them, and say here's what it is, because I mean, again, they already decided what they're doing.
To a large degree, right. And I think that's what we're looking for is this the case where maybe I can change someone's mind a little bit?
Yeah.
Because if they're well prepared, they're of course going to form opinions before they begin here. Most of the people are really not.
No, and I mean, you may have an issue that does swing an appeal. It's like, okay, this is the issue.
Yeah.
It's all on the wrist. All right, you may be seated. Get my paper straightened out here. And my computer.
I think Judge Edwards is going to give me leave of court to correct my last statement that my colleagues are both former trial judges. It was his father, Judge Edwards' father, was a trial judge. So,
Judge Harris, of course, was a trial judge.
right. So,
As was my father. Both our fathers.
just didn't want to mislead you folks.
All right, and we are to our third case, Cooper versus Gonzalez. And counsel, whenever you're ready.
May it please the court, I'm Warren Kwabnik on behalf of the defendants, appellants, Kip Cooper and Classic Plumbing of Brevard. I'd like to reserve 5 minutes, please. The jury in this auto negligence case awarded nearly $900,000 for claimed injuries to the plaintiff's neck, back, and shoulder. We're asking that the court reverse for a new trial. We've raised 3 issues on appeal. With my time, it is my plan to talk about my first 2 issues and rely on my brief for the third involving the jury instruction. Although, of course, anything the court would like to discuss, I'm happy to do so.
Well, thank you.
That's why I'm here, Judge. On our first point, we believe the trial court abused its discretion in excluding certain testimony from the defense orthopedic surgeon, Dr. McBride, to the effect that the plaintiff's low back herniation was not caused by the subject accident.
It's your time, and you can use it however you want to. From what I could see, Dr. McBride waited pretty doggone late to look at the records and came up with opinions pretty doggone late. And after the first trial, correct me if I'm wrong, but after the first trial, pretty quickly, a blanket order was issued on rollover cases that these cases are done, they're ready to go, and they'll be set for trial in November or whatever it was. Is that basically what happened?
That's basically it, yes.
Okay.
So what we're dealing with here, and when the case comes up for retrial, Dr. McBride's new opinions are excluded. And we know, and this is where I think the judge, of course, committed an abuse of discretion. We know from the Binger case and all the cases that follow it, that the trial court's discretion to exclude an opinion that's rendered untimely under the court's order has to be guided first and foremost by a determination of surprise or prejudice, also considering opportunity to cure the prejudice, as well as other factors such as good faith or bad faith. The case law tells us that it's error to exclude an opinion even after the court-ordered deadline when there is no prejudice to the opponent, and I think that's what we have here. Dr. McBride solidified...
But something, that's got to be an end at some point.
Well, of course.
I mean, I'm not following that argument.
Well, there would have been no prejudice to the plaintiff by allowing Dr. McBride at the retrial to testify that there was no causation between the accident and the herniation. The plaintiff was aware of that opinion by virtue of it having been disclosed during the first trial 46 days before the trial.
But I thought the new opinion was somehow different because it's a new opinion.
No.
The opinion, again, correct me if I'm wrong, but McBride kind of went from, I can't really link it, like a second opinion was, I'm thinking it'd be hard to link it, and then the third opinion that defense really wanted in was, it ain't related, it's not causally related, and the care wasn't needed, right?
Correct. And the definitive no causation opinion was disclosed in the midst of the first trial 46 days before the second.
The defendant agreed was definitely untimely, and you alerted plaintiff's counsel to this untimely opinion, right?
Correct. And that's why everyone agreed it wouldn't be presented during the first trial.
And how many days after that trial ended with a mistrial was this blanket order that came out saying, no more discovery, no more anything?
I can tell the court...
A few, right? Just a few?
Oh, yes. It was very quick.
Right. And then it was set again for trial in November. This was October, sometime in October.
About a little over 6 weeks between that.
Okay. But if you wanted to bring up this new opinion that was admittedly untimely at the first trial, why wasn't it raised and said, Judge, we want to get this new opinion in so that he could be put up for deposition or whatever else? I mean, as my colleague related, I was a trial lawyer. If you had a problem and you had a mistrial somehow and you had evidence that was excluded in your first trial and you wanted to get it in the new trial, you'd go to the judge and go, hey, Judge, I know it wasn't fair then, let's take care of it now. Right. And that didn't happen.
No, that would have been the cleaner way to do it, of course. But in terms of whether the plaintiff was aware that we were going to attempt to bring in this new opinion, after the first trial, Dr. McBride issued a more formal recitation of his new opinion. Everyone was aware at least 27 days before the second trial that we were looking to present Dr. McBride's
As Judge Jacobus said, these aren't guidelines and suggestions, these are court orders. If you want to get around a court order, you file something called a motion and say, hey, we need relief from this part of the order because.
Yes, that would have been, in retrospect, certainly the better way to have done it. But in terms of what analysis guides the court's discretion in excluding that opinion, we need to apply a Binger analysis. And
did you object? And when I say you, did trial counsel object at trial that said, Judge, you haven't applied Binger to this case?
I don't know if he said you didn't apply Binger, but he certainly argued for a Binger analysis, saying that, Judge, you need to consider surprise and prejudice. They knew about this weeks ago. And so the argument was made with citation to Binger, and the judge's analysis began and ended with the idea that my order is not a suggestion. And certainly that's true. But Binger presupposes that there's going to be a violation of a court order. That's always the case with Binger, because if it was a timely disclosed opinion, there would be no problem at all putting it in. So you're always going to have some type of issue with the timeliness of the order when you do a Binger analysis. And we've cited cases in our brief, Lugo, for example, where the court excluded an opinion on the basis that the judge said, quote, the order must be strictly complied with. And the appellate court said that's an indefensible ruling where the opponent was aware of the substance of the opinion.
But didn't the judge here find there would be prejudice to plaintiff to allow the testimony?
I don't believe he made any finding of prejudice. I think his analysis...
It was certainly discussed with the judge, wasn't it, or no? Are you saying it wasn't discussed at all?
I don't know that it may have been discussed at all, but he certainly made no finding of prejudice, and I don't think the record would support that. With the plaintiff aware of these opinions long before, certainly there was an opportunity to cure it. And the other thing, too, in terms of the ability of the plaintiff to meet Dr. McBride's opinions, although Dr. McBride was not able to talk about the 2013 scan that showed the herniation, Dr. McCollum, the plaintiff's expert, was able to testify that, yes, I'm aware of the 2013 scan. It may show a herniation, but that's really not what that film was for, so I discount it completely. So they were able...
Do you argue that that opened the door for McBride's opinion?
It was addressed on the front end.
No, that's not my question.
No.
Once that was brought up, I mean, I could see an argument being made. I'm not saying it would be successful or not, but hey, if they're going to talk about it, our guy gets to talk about it.
I believe that was addressed when the issue came up at the beginning of the trial, because if I recall, my trial counsel said, well, Dr. McCollum is going to testify about his review of the same records, and the response was, well, he's not an expert, he's not bound by disclosure things, he's allowed to testify about those things. So that type of issue, I believe, was brought up on the front end of the issue. It was not, to my recollection, raised again as now the door's been opened, because we'd already discussed it in the judgment.
I keep talking about that. It's fine. If you'd like to address the permanency directed verdict, that'd be more to my liking, but it's your time. So.
Oh, well, thank you, Judge. Yes, and our next point is we believe the court erred in granting a directed verdict on the issue of permanency. Again, the plaintiff had 3 body parts involved here, the neck, back, and the shoulder. Everyone agrees that the directed verdict on permanency pertained to the shoulder injury. The defense expert in this regard, Dr. Halperin, testified unequivocally that he does not assign a permanent impairment to this, and he does not consider this to be a permanent injury. He said, yes, she had an orthoscopic procedure. It involved a little bit of bone being shaved down. And what he said was, if you want to define permanent injury as something's different in the body, then I guess you could say that. But that's not how I define it. He found that she does not have a permanent injury because her shoulder is fine. In addition, on top of that, we know that for, I believe, 2 years prior to trial, the plaintiff underwent no care for her shoulder, and there was no evidence she would ever need anything further for her shoulder.
Did Dr. Kugler, I think his name is, he was the shoulder surgeon?
Yeah.
Did he testify at trial?
He didn't testify. The only evidence of permanency with regard to the shoulder was in Dr. Kugler's record, where he assigns a 6% permanent impairment. And I don't even know if that evidence is what the judge relied upon to find that there was permanency. I think the judge was under the impression that anything changed in the body is a permanent injury as a matter of law. It doesn't matter what anybody says, and that's wrong procedurally and substantively. What we have in this case is unobjected to expert testimony that this plaintiff does not have a permanent injury to her shoulder. It's not for the court to say that unobjected to expert testimony is entitled to no weight and I'm going to grant a directed verdict. The other point is, as a matter of substance, I think the judge was under the impression that there's some kind of legislative definition of permanency, and there's not. We know from the case law and the instructions that there's been a deliberate attempt to not define permanency. We leave it to the experts to tell juries what permanency is. This expert says there was no permanent injury. There's one case I cited to the court in my reply brief. It's Emanuel versus Purdue, 693 Southern 2nd, 1071. It's a 4th District case. In that case, the plaintiff underwent a TMJ surgery and the jury awarded medical expenses associated with the TMJ surgery, but found no permanent injury. The defense expert in that case said, notwithstanding the surgery, it wasn't a permanent injury. The trial court granted a new trial, and the appellate court reversed. Essentially, the result being the fact of a surgery doesn't necessarily mean permanency. Yes, there is something somewhat different in the body, but any surgery, no matter how minimal and no matter how small the change, isn't, as a matter of law, a permanent injury under Florida law. We had an expert saying there was no permanent injury, and for those reasons, it was wrong to grant a directed verdict.
You cited as well to Little versus Davis, correct?
Correct.
Surgery there, and the jury was free to find no permanency?
Correct. And yes, we did.
Let me ask you about the Wald versus Granger case.
Okay.
The Supreme Court version. In that particular case, it said that it agreed that typically, permanency is an issue for the jury. But if you have a situation where there is no evidence, no conflict in the evidence, then permanency can be part of a directed verdict, correct?
Right.
And in Wald, the plaintiff's experts said the plaintiff had a variety of permanent injuries. And one defense expert, a fellow named Dr. Howard Hogshead, agreed with the plaintiff that the thigh injury was permanent, correct?
That's my recollection.
And so the court upheld that permanent injury DV, right?
I honestly don't remember that.
Right.
But my take.
The Wald case, even though it upheld that DV, placed certain limits and parameters on when a DV was proper, right?
My understanding, broad view of the Wald case is that even where the experts agree that the plaintiff sustained a permanent injury, there are circumstances where a jury can reject that and find that there was no permanent injury. For example, if the experts had incorrect medical histories, we don't even need to reach that. That's a case that tells us even where all the experts agree it was permanent, a jury could still find no. We don't have uncontradicted evidence of permanency here.
Not exactly what the case says, but
I'm sorry.
It says you can, but you can't just up and disregard all the experts. There have to be reasons to disregard the experts.
Oh yes, the jury can do it with reasons, and such as an incorrect medical history that was given to the doctors.
Did plaintiff in this case argue, as far as the permanency, anything other than permanent alteration of the body?
He initially argued significant scarring, but then ultimately agreed the significance.
He agreed that was a jury issue, right?
And everyone agreed that the other ones, like loss of an important bodily function, was not at issue. The only one at issue was permanent injury within a reasonable degree of medical probability.
Right. And was there any testimony from any plaintiff's expert, testimony at trial that there was a permanent injury?
No, I don't believe there was.
Let me just ask you this, and so I can put plaintiff's counsel on notice to look there on his computer. I'm looking at Dr. Kugler's report at 2055 in the record, and it says, I think this must be the report that everybody referred to, under the treatment section at page 2056. He says, others, clinical note, the patient at this point is doing very well concerning her right shoulder. She will be finalized. She is given a 6% impairment rating. Is there anything else about her having an impairment rating that you know of from the plaintiff's side?
No. I'm not sure that's the same medical record of Dr. Kugler that I've been citing to, but it's substantively the same. I was looking at a medical record from Dr. Kugler that assigns a 6% permanent impairment rating. That's substantive.
While you're waiting on rebuttal,
I will do that.
Listening carefully to what he says, you can see if that's the right one or not.
Very good.
He can let me know if it's the wrong one. That's fine. But
okay.
Now, your expert was asked about Kugler's impairment rating, and he said basically that impairment rating is based on loss of motion, and I find no loss of motion, correct?
Yeah, he said a permanent impairment rating for this kind of injury is based upon range of motion, and whatever Dr. Kugler found at the time, I don't find a range of motion problem now. So he disagreed that there was a permanent impairment, and he also specifically said that there was no permanent injury because he doesn't consider this to be a permanent injury. But other than Dr. Kugler's medical record or report assigning a 6%, no, nobody testified at trial that there was a permanent impairment as a result of the shoulder. So I'll reserve the rest of my time.
All righty.
Okay, thank you.
May it please the court.
Morning.
Brian Lee, representing the appellee in this case, Ms. Gonzalez. I'm just going to go right to what we're talking about here, and the permanent injury. Obviously, we have arguments on the other 2 points, and I'm happy to go through any questions you have, but we are focusing on permanency. The evidence that the plaintiff had put forth through the medical record, and you are correct, we're looking at 2056.
That's the right record?
That's the right record, Your Honor, because it's talking specifically about the right shoulder. It's talking about basically the surgery that had taken place, as well, because it was 3 months, so this was a follow-up visit. And Dr. Kluger in that record says, as I think the court read, it says she will be finalized. She is given a 6% impairment rating. Okay, so there's and then later on in that same medical record, Dr. Kluger does talk actually about future surgery, future medical care that he believes that Ms. Gonzalez was going to need. He also said that she was at maximum medical improvement, and that she can come back. And so that was the evidence that was from the plaintiff's side. Under Wald and the portion of Wald that I cited to, what Wald says, or what the Florida Supreme Court says, is that the plaintiff has the burden, the initial burden, to put forth a permanency evidence. By this record, that did that. Once that's done, then the burden shifts to the defense. And what Wald says is that the defense has to put forth countervailing evidence that countervails it directly, meaning that, and they actually say direct evidence of permanency. So it's not a situation where a defendant can come in and say, well, I don't think that there is one, but I can't say that within a reasonable degree of medical probability, or something along those lines. I kind of call it the wishy-washy defense, right? You have to.
That was McBride's first opinions.
Right. You have to come in and you have to say that I'm directly saying, as an expert, the defense expert, that there was no permanent injury. Now, this is a unique situation because normally when we're dealing with permanent injury, we're talking about separate injuries, right? So like this one, we had a shoulder injury, we had a back injury, neck injury. So we have separate injuries, and then we have a fight from physicians that one says shoulder, one says not. One may agree that there's a neck injury and there may not be any disagreement, but there's disagreement on the other. In this case, the defense expert himself disagreed with himself. And he said, and I've cited to this in my brief, when he was asked a direct question whether there was a permanent anatomical change in the body, he unequivocally said yes. He then says, well, I think of a permanent injury as a loss of bodily function. And she didn't have that. So I don't think she had that.
Where is permanent anatomical change a permanent injury? I looked at 627, 737, and it's 2A, B, C, D.
It's not in there.
It's not in there, is it?
Doesn't say anatomical change at all.
And that was your argument, that there was a permanent anatomical change, and Judge Jacoba said, yep, that's permanent injury.
The trial court, yes, the argument was that the specific argument was that that testimony satisfied a permanent injury under the statute.
Right, but permanent anatomical change
Correct.
is not listed under the statute.
It's not. And
there was testimony from defense expert that there was not a permanent injury, right?
I would disagree with that to the extent that he said that this part of my analysis, I don't think there was a permanent injury. The other part of the analysis that I make, yes, there is. So he said two different
he didn't
things.
say permanent. He said if you asked
Permanent
if something
anatomical
was
change.
changed.
Absolutely. But he said it was permanent.
Words matter, right? Permanent change, he said, yes, there was a permanent change. I mean, if you had an appendectomy, that's a permanent change to your body, your appendix is gone. I don't know, I've never had it come up because nobody knows what the stinking appendix does, but, so you've had a permanent change of your anatomy, just like, you know, this person had a permanent change through shaving of the shoulder bone, but the doctor said, that's not a permanent injury to me.
But he didn't say that. My argument is that Wald says that there has to be a direct contravention, meaning that there is no permanent injury, period.
Wald says, and I'm looking at page 1204.
Yes.
Nonetheless, where the evidence of injury and causation is such that no reasonable inference could support a jury verdict for the defendant, it's not improper to direct a verdict on that. And a directed verdict, again down at 1205, a directed verdict is proper when the evidence and all inferences from the evidence considered in the light most favorable to the non-moving party, the defendant obviously. As a matter of law, there's no evidence to rebut it, and it goes on to say, so when you examine the record, you need to determine if there's any conflicting evidence or inferences on the issue of permanent injury from which the jury could draw a conclusion favorable to the party against whom the DVs. And well, there was testimony from defense Dr. Halperin that it was not a permanent injury. From that, the jury could draw the inference and reach the conclusion that there was no permanent injury.
But there was also testimony from him that and again, I understand when we're looking at the statute, we're talking about injury, right? There's a term in there. It's not defined.
Right. It's not defined at all, and
it's
they
not defined.
they pointed out in the standard jury instructions, it's not defined, so don't try to define it. Leave it up to the experts in argument.
Sure, but when we have an expert, which we do in this case, that says in one instance there is a permanent change, and then one instance says, but in this other part of her function, I don't think that's permanent. That is not a direct, what Wald says, a direct conflict with the plaintiff's evidence.
There has to be a direct conflict within 2A or within 2B, but you can't say there's conflict between 2A and 2B under the statute. Does that make sense or not? In other words, 2B deals with permanent injury. So your argument would be that once you put on evidence there's permanent injury, they've got to come back with direct 2B, meaning permanent injury, evidence to counter that.
Yeah, I think I know where you're going, Judge. The way I would say it is that the statute is set up as an or. You either have to prove there was a permanent loss of function, or a permanent injury, or I think it's permanent scarring, if I'm not mistaken.
If you put braces on somebody's teeth, that results in a permanent anatomical change. When you take the braces off, you'd say that's a permanent injury?
I don't say it. I think that I think if a doctor came in and said that there was a permanent anatomical, now again, we're talking about a negligence case, but if a doctor came in and said there was a permanent change that those braces made to her body, and there's evidence that she's going to continue to have future treatment for that injury, that's permanency.
But you keep throwing injury in there.
Or change. I don't think the injury word has some kind of magical word phrase meaning that an expert has to say that it's an
injury. Change and injury is certainly not synonymous.
I'm sorry, what?
Change and injury are not synonymous. You're using them the same way. A permanent change is not necessarily a permanent injury.
I think the words change and injury are not synonymous, but permanent is.
Right, but permanent,
When you say permanent change, that by definition is permanent. When you say permanent injury, it's by definition permanent. We're talking about permanency.
Yeah, and we're not trying to mince words over permanent versus temporary. I mean, whatever the change was to her shoulder as a result of the shaving was permanent.
Right.
Nobody's disputing that. The question is whether it's a permanent injury. Unless it's a permanent injury, you can't get these other damages, right?
That's what the statute says, permanent injury.
Right. The statute says
But we don't
permanent
know what the
injury.
injury is defined as.
Your fella Kugler, and since defense didn't make a big deal out of it, I won't, but he says she's given a 6% impairment rating. It doesn't even say permanent, but they accept it as that. Everybody who's in the business knows that's a permanent rating. It doesn't get better, doesn't go down. It's going to be 6% when he says finalized. So he gives her the permanency rating, and Halperin says she doesn't have a permanent injury. And if Wald says you leave it for, and the jury instruction committee says you leave it for arguments and you leave it for experts, that didn't happen here. It was taken away. It was taken away. They weren't allowed to argue whether she had a permanent injury or not.
There is obviously a disagreement we have as to what that is.
Tell me the case that says a permanent alteration of the body equals permanent injury.
There is none. I can't find a particular case.
There are cases that he cited to us, and we discussed. I don't mean to be interrupted. No, calm down a little bit. But
your time.
There are cases that say somebody can have surgery, the TMJ surgery, some neurological surgery, and the jury's free to find, despite surgery, that it's not a permanent injury. In fact, it was error. I think in one case they reversed granting a new trial or a DV, whatever. But I mean, how can you have TMJ surgery and neurological surgery, and it's okay to say that's not a permanent injury, but you shave the bone when the doctor who testified says that's not a permanent injury? Change, but it's not an injury.
Right. I mean, and the one thing I don't know, Judge, is in those cases, was there questioning about, the permanency of the surgery? Because there are situations where if you don't ask the question of the doctor that says, hey, did your surgery, just the surgery, cause a permanent injury to the body, then you can't bring that up. You have to then rely upon, oh, well, I think her pain's permanent, or I think the other things. So I don't know we can look at those cases
They're not as clear as you'd like.
And figure out.
Yeah, I mean, it says she had TMJ surgery, so that means they cut her open and did something with her jaws. We don't know what.
Right.
And the other one was neurological, and that was even more vague. She had neurological surgery, but the doctor said she would be doing better and continue to improve. And the Court of Appeal said, well, no DV on that, just because she had surgery. That's up for the jury. And that's really kind of where I see this.
Right.
And I understand what Kugler said, and they didn't fight that on any kind of basis. But when you've got Halperin saying there's no permanent injury, and you got Kugler saying there is, that's the classic question for the jury, isn't it?
I disagree, obviously. But the way I look at it, and just to kind of end up, unless you have any questions, the way I look at it as this is no different than having a situation where there are two different parts of a shoulder that are injured, one of which heals fine, and one of which doesn't. You can have an expert, and this expert, we believe, said that as to this part of what happened in this surgery, that's permanent. He said change. He said anatomical change. I don't believe that automatically just takes it out of permanent injury, that it's not a permanent injury. He also said that as to the effects of this, I don't believe the effects of this are permanent. So he has two different opinions, we believe, one of which says there was a permanency, one of which says there's not. And there's a cause and effect to that.
I'm sorry, go ahead.
No, and all I was going to say is that Wald, in our view, says that you have to have a direct conflict with the evidence. If the plaintiff's evidence is that there is a permanent injury, and the defendant's evidence is that one part is a permanent injury and the second part isn't, that's not a conflict. Because the expert has said that there is a permanent injury.
If he just said the shaving the shoulder was a permanent injury, you're home free. He didn't. He said it was not. He said he doesn't think it's permanent anatomical change. And again, Wald says if there's any conflicting evidence or inference on the issue, there was conflicting evidence on the issue of permanency of the shoulder by the two two doctors, one from the defense and one from the plaintiff. And, you know, I guess we beat that horse as much as we need to. You're free to talk. You've got time left if you want to talk about anything else.
No, Judge, the only thing I was going to, the other two, obviously I've briefed, just to touch on the first issue about the disclosure and those types of things. The one thing I would say is that prior to the trial, there were the two reports done by the doctor, and neither of them said what the opinion said. When we got to the first trial, all of a sudden now there's the opinion. What I would also add to that is that as part of that trial, the defense counsel not only said, we're not going to have that opinion, we're just going to read his testimony. You know, we're going to have him come in, and he's not going to testify about that. When now we go to the second trial, it was mistried for a reason that's not in the record. The only thing that I can gather is from a motion that said that the judge said it wasn't fair. It wasn't a fair trial. We don't know what that is, but
nobody appealed it.
But nobody appealed it. And so what we do have is we have the trial judge days afterwards enter an order which specifically says discovery is frozen. Frozen's my word, but essentially there is going to be no discovery. And then after that, even with that, we have a new report. Binger specifically talks about the discretion a trial judge has, and specifically says that a trial judge has almost absolute discretion about how it's going to enforce its own orders.
And it let the testimony, McBride's testimony, come in as to the old things he had to say, right?
They did.
Not as to the new opinion.
Right. They read the transcript, from the first trial as his testimony.
It's not the plaintiff's job to make it easy for the defense expert to come in with a new opinion, right?
No, and the trial judge.
They did nothing that you would have expected when you get the order saying it's frozen, we're done, let's go. This one's baked, let's just go try it again. They did nothing pre-trial to try to seek relief from that order, did they?
Not that I can see.
Oops. So, okay.
I'm sorry.
Go ahead.
On the third issue, I'm struggling a little bit to see why it was not an incomplete instruction by having the limitation for permanency as to just the right shoulder, because that's the only portion of the body that was at issue, correct?
Correct. So the reason that we believe that it was an appropriate instruction is that when you look at the standard instruction for permanency, it doesn't differentiate between different injuries.
Well, okay, the standard instructions only get us out to the starting gate.
Sure.
They don't, okay.
But I think the bigger part of this is to go to, I think it's Wald again, because Wald talks about that when there is evidence, when the jury finds, or its directed verdict of that there is a permanent injury, right, it's A, then you can get those damages for all injuries.
Whole or in part.
Whole or in part, right. And so that's what the trial court looked at, and why we think it's appropriate to have that jury instruction, because number one, they gave the instruction as the way it was supposed to give, and the way that the law says you're supposed to, because it's a permanent injury. But then number two, the trial judge did not stop the defense counsel from talking about, the shoulder surgery, the judge said, but basically explaining the instructions.
But couldn't the jury have felt, okay, well, they said there's a permanent injury here, and we find that it's to the neck and back, therefore we're going to award damages as to those?
They could have said that we believe that the neck and back are permanent. They could have also said, well, we believe with what the defense counsel just said, that it's really the shoulder, and that's it. So we don't know exactly. It's kind of it's speculation to figure out what the jury said, but the instruction itself, meaning there was a permanent injury that was found.
A permanent injury,
right? And it doesn't say, the instruction doesn't really give, and frankly the law doesn't give the ability to parse out injuries in that sense for a jury instruction.
Didn't she have a lumbar fusion?
She did. She did. But there was evidence that that wasn't caused. Right, so it was very direct. And again, at the end of the day, the instructions given, counsel was able and extensively talked about what the jury should do. about the injuries. And so I believe that the instruction that the judge gave was appropriate according to not just the standards,
If
but
the
the law.
judge had put in the limitation, though, would that have been a problem for you? Would you have appealed?
Frankly, I think it would have been a problem because part of, and not for the permanency aspect of it, for the damages part of it. Because even if a court says, or directs in this case, a permanency, you can argue damages. And so you can argue, in this case, that the lower back shouldn't factor into that damages claim because it wasn't something, our doctor said it wasn't permanent. So you can make those arguments, I think, but it's more alongside the damages part of it rather than whether there was a permanent injury. The permanent injury instruction only allows you to get that question off the verdict form. The jury doesn't have to check yes to that question now. The damages questions are still there, and all the arguments are still available for those questions.
And that's your last argument. Thank you. You're out of time.
Thank you, Your Honors.
All right.
First, citation to 2056 is what I had been referring to, so I think we're all talking about the same record from Dr. Kugler.
You agreed from reading that document that Kugler was of the opinion that it was a permanent impairment of 6%, right?
That's what it says, certainly.
Okay.
Whether an impairment equates to a permanent injury, I guess there's some debate about this.
But that's what you ask a doctor, it's a permanent injury, they go, well, that's a legal term, we say impairment, right?
Right, and this is a medical record, so it makes sense that it would be speaking in medicalese rather than legalese. A few points. On the directed verdict issue, I think I understood counsel to argue that there was something internally inconsistent with Dr. Halperin's testimony, but I don't think that's true. I think Dr. Halperin was specifically distinguishing a permanent change from a permanent injury. He wasn't inconsistent. He was saying that these are two different things. What he said is, the way I define permanent injury, she doesn't have a permanent injury. Okay, you can't be more definitive than that. He says, she's fully functional. If you want to define a permanent injury, something is different inside of her body than it was before, you could say she is. But the way I would define a permanent injury is has it limited her after she's done with everything she went through? Is there a problem? Is there a limited motion? If the answer is no to all of that, I don't consider it a permanent injury. It's a clear, definitive, unequivocal. It's not an initial McBride opinion. It's a specific Dr. Halperin opinion. He's not internally inconsistent. He's saying that it's not permanent. Wald didn't change the standard for a directed verdict. We know you take the evidence and all inferences in the light most favorable to the non-moving party. Wald gives us some scenarios when a jury can reject undisputed expert testimony and still come to the opposite conclusion. That's not us. We have conflicting expert testimony.
In the Wald case, the judge directed verdict on permanency only as to the thigh. I'm telling you that because I know that. I'm asking you the question that I don't know the answer to right off the top of my head. Did the judge, and that was a he or she, did the trial judge in that case give the standard jury instruction that there is a permanent injury? If you don't know, don't feel bad.
I don't, and I want to talk about the instruction. It was my hope to rely on the brief, but it did come up, so I do want to address it. Before I turn to that, though, with regard to the distinction between impairment and permanency, I think the Purdue case, the one that we talked about earlier, if I recall, the defense expert in that case said that TMJ surgery was rateable as a permanent impairment. I believe he said that. I was not able to pull it up when I went back to counsel table, but he still said, but I don't find it to be a permanent injury. So I think this demonstrates that among medical professionals, something could be rateable as an impairment, but still not a permanent injury. And of course, the court in that case said it was a jury question whether the TMJ surgery was permanent or not. So we think that was error. With regard to the instruction, I don't disagree that a permanent injury to any body part here would allow non-economic damages as to the entirety. But that's not the problem with the instruction that the judge gave. By telling the jury that it's been determined that this accident caused an injury and a permanent injury, without saying that this was limited to the shoulder, it wasn't purely about what could the jury award non-economic damages for. It's suggesting to the jury that more than just the shoulder injury has determined to be permanent. It it's telling the jury that it's suggesting to the jury that these injuries that you could find are not even caused by this accident are caused by this accident and are more severe than the jury might actually find. It's not just about the permanent
instruction
injury.
said there was a permanent injury, and whether or not the directed verdict should have been given. Once the directed verdict has been given, to say that the court instructs you that there was a permanent injury left defense counsel total freedom to go, well, shoulder, everything else is not related, don't give any money for that.
Well, and that's their argument. They're saying we weren't constrained in our closing argument, and that's true, but we know that the jury instructions are instructions from the court. The lawyer argument is lawyer argument, and if it's going to be perceived as conflicting with the instruction or being in tension at least with the instruction, that doesn't solve the problem. That makes the problem worse. Now you have a lawyer who's saying something that could be viewed to be not consistent with what the instruction is. There was no reason why, and I understand, the argument is we need to stick absolutely and strictly to the standard instruction. Not every scenario is covered by the standard instructions. We have 3 discrete body parts at issue here. The directed verdict was only as to the shoulder. There was no reason to tell the jury that she suffered a permanent injury, but the defense is going to dispute the spinal injuries. I think there was, and as far as speculating what effect it had on the jury, we know that we can't get inside the jury's heads, and that's why the standard on appeal is there a reasonable likelihood or a reasonable possibility that the jury was misled? You don't have to show a certainty of them being misled. I think this instruction certainly did create a reasonable likelihood that this jury was led to believe that the ruling was not limited to the shoulder. If we look at what the verdict was, every dollar requested was awarded plus substantial non-economics. There's no question the jury awarded for all the body parts. And as far as the low back surgery, of course, yes, she had a low back surgery, but causation was the issue there, and that was part of the instruction that the judge gave. So unless there's any other questions, we would ask the court reverse for a new trial.
No, it doesn't look like it. Thank you very much, and thank you both. Very well briefed, well argued, and we will be in recess.